Okay, I'm going to do the official welcome, right?
Yes, yes.
So welcome, everybody. This is promoting step family harmony through smart estate planning. And it's particularly important for step families because step families often find themselves in the middle of contested wills and estate battles, and stepmoms especially are vulnerable. So when I met Patricia Fonte, estate planning attorney, this was a few months ago. I met her at a networking event for women, and I knew she was the one who could help us stay out of court and avoid trauma. And Patricia is the founder of San Francisco-based Fonte Law. She and her team practice, what do you practice? Estate planning with heart. I love that.
Trademark pending, yes.
So she's not only a prominent attorney, she's a trusted counselor. She is a connector, and this I know. And so we're really happy to have her do this encore presentation. I'm just so thrilled and grateful. She is also a published author. And let's see, you wrote about finding security in times of strife. It is part of a tome on estate planning strategies. So yay, can't wait to read that one. She is going to take questions, as she said. You can put it in chat, or at the end, we'll have a little Q&A too. So I'm going to turn this over to the generous and gracious Patricia Fonte.
Thank you so much. Thank you for giving me a soapbox and a platform to let me talk about something that is so important to me. Why do I care specifically about step families? Well, two of my closest friends are mothers in step families. And I didn't know how to help them when they were getting a divorce because I wasn't practicing estate planning law at that time. And I just didn't know how to be there. I didn't know what they should be thinking about. And so estate planning, it's for everyone and it's about everyone. But of course, the particulars are sometimes the most important part. And so what we're really going to focus on today is I'm going to go over the generals through the lens of additional considerations for step families. I'm going to do a screen share. You are going to forgive me for not having a gorgeous PowerPoint presentation. I can't put my energy into a gorgeous PowerPoint presentation. I have a Word document. You'll see me write on it, highlight it. Disclaimer, I can't give anybody legal advice. So you get legal advice from an attorney after you have signed an engagement agreement and you have paid them. It takes a lot of energy from the lawyer to get down to the actual question. You might think it's a simple question, but the answer to any legal question is, it depends, tell me more. And now tell me more about that. And then tell me a little bit more. So we're not going to have any easy answers today. We're going to have food for thought. And if you at any point get this defensive feeling of not me, I don't need that, I want you to put that aside, because the basic things I'm going to talk about is, yes, you do need this, because estate planning is for every single person. It's not about how much money you have. It's about family harmony, protecting yourself and protecting the people that you love. So this is going to be a screen share for most of it. So you don't have to look at my face. We're going to look at a Word document together. So estate planning is really about preserving family harmony, protecting the survivors. And that means you. If you are the survivor in your marriage or your union, protecting you, and then of course the children and the other beneficiaries, and promoting your values. And it's about tax. It's always about death and taxes. We can't get away from that. So who am I? Susan gave me a little bit of an introduction. I'm the founder of Fonte Law, where we practice estate planning with heart. What that means to us is that we want our clients to be happy and empowered. We want them to feel good when they first meet with us, and even better as they leave us. We believe that Black lives matter. Love is love. Women's rights are human rights. Families belong together. Stop Asian hate. And we are ruthless. Contributing author. Natural Resources is a local nonprofit that my firm has supported for years. They were there for me when I was a new mother. And I just got, they called me this morning. I'm like, village member of the year or something. I don't really know yet what that is, but that's fun. I have been designated as a super lawyer for the last few years, and my firm won a torture award for ethics, which they tell me is rare for lawyers. So this is the bad news. Okay, so brace yourself for this bad news. And I'm not going to assume that everyone here is married and in a step-parent relationship. Some of you might be in committed relationships. You are acting as a step-parent, but you're not married. And so we have to kind of talk about both scenarios. So here's what happens, whether you're married or not married, and you bump your head, you lose capacity, you slide into dementia, and you don't have a durable power of attorney and an advanced healthcare directive. Hopefully it is someone who loves you and not someone who wants to control you, will approach the court and ask for permission to step into your shoes, make decisions for you, and act as you. And that's called conservatorship. People kind of feel like they know what conservatorship is now because of what happened to Britney Spears. It's an extreme example, but it's not an isolated incident. It's very important to take control and make sure that nobody has to go to court and tell the judge she can't use the bathroom by herself. She's giving her money to a Nigerian prince, whatever the things are, and then try to be in that position to make healthcare decisions for you or to make financial decisions for you. Probate. So the number's a little bit out of date. I think now it's around $182,000. It's stuff. So these are not your bank accounts, not your retirement, not your life insurance. This is your jewelry, your art, all the things that you have, your cars. It's also the real estate. And it's not how much you own, because I hear from people all the time, well, the bank actually owns it. No, not in the eyes of the probate court. You own it. So you have to look at the fair market value, and this is what the lawyer gets paid, and that's what the executor gets paid. So this is an epic waste of money. Estate planning does not cost this much. It also takes, I'm in California. So I'm a California lawyer. I'm in the Bay Area. I work with clients all over California. Here in the Bay Area and in the major metropolitan areas, going through a probate in California can take a couple of years. And these are generally the numbers. This is the low side of the numbers. If you have minor children, they are placed where it's necessary and convenient. So off you go for date night, and you don't come home. You're in matching temporary twin comas at your local hospital. You're not coming home that night. And where do the children go? Please decide. Oh, love that. So we really need to think about where the children should be, either temporarily or permanently. So let's look at who gets your stuff if you do nothing. So you have children, but no spouse. And really look at this. If you are in a committed relationship, but you are not married, if he has children, they will inherit everything and you will get nothing. Huge big deal. You're living in his house. He dies. You don't automatically, I mean, you can bring a lawsuit and say, this isn't fair. I want some. But in the first instance, you get nothing. Maybe you're in an unmarried couple and he's living in your house and now you've died. And now what? Now where's he going to go live? You love this person, right? You unmarried couples, you really have to take care of each other. You do this through estate planning. You have to make you have to take very affirmative steps to care for the other. Now, what might be a very typical situation here is that we have a spouse and then there are some children. And for those of you who are in these blended families, you're probably very aware of what is separate property and what is community property, or whatever that equivalency is in the state where you live. And so it might be that your spouse inherits all of a certain kind of property, but the kids get a different kind of property. So you have to be very careful here also. Where did the real estate come from? Where am I going to live? Where are they going to live if we don't have an estate plan and this hasn't been addressed? So you can, I'll just leave it for a minute, just kind of find yourself in there. And this is California's default plan. It's pretty, I would imagine, pretty similar statewide. If you are wondering, this is really easy to look up. You just type in the name of your state, and then you would type in intestacy laws, and then you should get some code sections that come up that tell you this. Don't go off somebody's website, look up, get the codes. The difference between community and separate property in California is when you're married, if you don't have a prenup, every penny that you earn while you're married is a shared penny. And it doesn't matter if you bury it in the backyard. And it doesn't matter if you always keep it in a separate bank account. And it doesn't matter if you open that business before you got married. It's a shared penny. If you don't like that, you need to opt out of that with a prenup or a postnup. Separate property is money you had before you got married that you didn't jumble up with your married money after you got married. It is an inheritance that you receive at any time that you don't jumble up with your married money. It is a gift that you received while you were married before that you don't jumble up with your married money, or it's a personal injury award. Don't let that you don't jumble up with your married money. Don't let your separate money, your married money, get all mixed up. Because if you get divorced, it's going to be a mess. And also for blended families, who gets what? What's community property? What is separate property? How do the assets flow? How does this all work? You don't want a surviving spouse in an argument with your adult children because everybody's fighting about the definition of community and separate property. This is really important. People fall down on this all the time. Couples with prenups will do all this work and get a prenup and then completely ignore their prenup and commingle and jumble up all their money. So to be very, very careful when it comes to this stuff. That was a great question. Thank you for asking. So estate planning is about three things that we saw from the default rules, right? What about my stuff? I don't want to go to probate court. I don't want to have my family pay those fees, spend that time, go through this terrible, stressful public process. What about me? Who's in charge of making my healthcare decisions? How do I honor everyone who's involved? How do I make sure that I'm not delinquent on my taxes, that my insurance is kept up, that someone has the ability to contact my employer for my disability payments? Who is in charge in these roles? And what about my kids? Kind of thinking about minor children, but here we have blended family situations. So we're going to dig into that a little bit more. We'll talk a little bit about tax. We'll touch on some other issues. No one is allowed to use a DIY online solution ever. You're not doing that. You have to work with a real life lawyer who's going to spend real time with you to get to the bottom of all the issues that you need to get to the bottom of. And we'll talk a bit about how to find a lawyer. Okay. In California, and in most places, you want to use a revocable or a living trust, not a will. In some states, lawyers say a will is fine because we're not worried about a court process after a death because it's very inexpensive, it's very fast. I don't care, even if probate was free and it was not a big financial issue. Even if you could wrap it up in 3 weeks and it wasn't traumatic and it was the most wonderful, easy thing in the world. It is public. Everybody knows exactly what the survivor is getting. And that could be a surviving spouse, it might be the kids, or a combination thereof. Also, there is no tax planning ability. There's no asset protection ability. There is no control from the grave. So no matter where you live, I am very concerned about privacy, asset protection planning, tax planning ability, and control from the grave. I don't like wills. I don't like them. It's too public. Maybe they used to be okay, but now we have the dark web. Everybody gets to know everything that's written in a will and everything associated with the transfer of assets under a will. So on the first death, we're looking at this. On the second death, after the first person has died, and maybe we've got some gifts to the children when the first spouse dies, we're going to protect the beneficiaries from the perils of inheritance, from creeps and creditors and themselves. 33% of heirs lose all their money within 3 years. So let's imagine you have adult stepchildren and your spouse dies and leaves you 50% and them 50%. And they blow through their 50%. Now what? It's not great. I would really rather that their money was held in them for trust, give them an opportunity within these 3 years to get their own financial advisors, get their insurance in order, maybe get their own estate plan done. Give them an opportunity to be successful with this money because these people have already been through trauma. They've either lost their other parent or the parents were divorced, right? And now they're losing another parent. It's a lot. I like to see a lot of scaffolding, a lot of loving language, and a lot of direction in irrevocable trust for all children, but especially for stepchildren, because they've been through so much. Let's create a document that is there to support them and doesn't just say, when I die, you get your money when you're 25, 30, and 35. A 35-year-old getting a full inheritance, the loss of a parent, it's a danger zone. And it's also a danger to the surviving spouse, because who else are they going to come back to and ask for money? And it'd be pretty human to say, I can't believe they left her all that money and she should still be helping us. Where you now are alone, you don't have another breadwinner in the house. There's no one to go out and hustle. There's no one to take care of you if you get sick. You don't have your partner anymore. And so we have to preserve that boundary between the assets and hopefully a positive relationship between the surviving step parent and the children. We always want to think about, beside the children, who's counting on me. And it might be other family members. It might be, if you have minors, it's the guardians. And maybe that's their other parent who isn't doing well financially. We're a little bit concerned. And so we were always thinking about, do we need to leave money there? Is that because we don't want economic disparity? The children are going to go live in another home. With step families, who gets what when is hard. We don't want children waiting for their stepmother to die if they've lost their father. That's a toxic situation. There is always, however, a concern, because we live so long now. Well, if I don't leave everything to my spouse, what if she runs out of money? What if she needs long-term care? And you're afraid to give it all to the younger generation. It takes a lot of finesse and care. Some of these things can be papered over with life insurance. You're never younger or healthier than you are now. So I would encourage everyone to go get life insurance right now if you don't have that in place. The who gets what when is really why you need to talk to a lawyer for a while. You need a lawyer who's going to ask you all about you, your families, family tree, both sides. If there are exes with more kids, like all of it, the whole family tree, who are all the players, and go through all of the assets. What's hers? What belongs to the other spouse? What's theirs together? What are we worried about? What are the kids like? What do they like? Do we leave money equally? Do we not? Is it equitable? It takes time to get down to the bottom of this. There's a lot of counsel that can be involved, and you shouldn't be pushed. It shouldn't be in that first meeting, well, what do you want to do? It should be a lot of listening and options, and then come back and look and see what it looks like on paper. Do that document review. Have the lawyer take you through the documents. Okay, when one of you dies, here's where the money goes. And here are the percentages. How does that feel? Right? You had an opportunity to reflect. And here's who we put in charge. How does that feel? And then you can course correct, or you feel good. Yeah, we made good decisions last time. Pats on the back. It takes time. There have been, so retirement accounts are an easy place to make mistakes. You want to make sure that your estate planning attorney understands the rules around retirement accounts. You know, it's tricky because, you know, one of the parents worked for a long time. They were married to someone else and they accrued this huge retirement account, and now they're married. And kind of usually the default is my spouse gets my retirement account, but this is a ton of money and you were doing this for yourself, and then maybe you had other plans for it. The laws and rules around retirement accounts are really sticky. There's a new-ish act called the Secure Act. It is not crystal clear. So you really want to make sure that whoever is drafting your plan doesn't make mistakes around your retirement account. I would say that someone's asking me a question, the average time frame to set up a trust. It is not weeks, it is months, because you need to meet with a lawyer and tell them all about you. And then they need to send you documents to look at, right? And if lawyer isn't sending you documents to look at. They are assuming that you are too dumb to understand and read documents. How offensive. I can't stand that. I want them to send you documents. At my firm, we send you documents and we highlight them in bright yellow. You can tell I really love bright yellow for the parts that we really want you to hone in on. We don't need you reading the rule against perpetuities. We need you reading the parts that say who is in charge and who gets when, what happens when one spouse dies, what happens when the other dies. So then you have to have this document review meeting and make sure that it operates the way you want it to, that you put the right people in charge. Sometimes more questions come out of that meeting, so you might need a few more weeks. I would say with our clients, 2 months is typical, because then there's a final meeting where we teach you how to transfer those assets into your trust. And you might also decide, we're going to have a family trust for our community assets and our children together. I'm going to have my own trust with my assets from before I got married, and that money is going to route to my kids. And he's going to have his own trust with his stuff from before marriage, and it's going to route to his kids, or a combination of me and his kids. And so it might be that you don't just have one trust. And that sometimes comes out of the document review meeting is, you know what, I'm not clear on this. I don't love the way this is structured. I would really prefer to have a separate document. And so it can just take some time. So you're looking at months, not weeks. So who do you put in charge? So, nice people who get along with white collar professionals, CPAs and lawyers. They have to be US citizen, US resident. And that's so you don't get IRS oversight. A good high emotional intelligence is really, really important. If you bonk your head and your kids don't necessarily get along with your spouse, your partner, you have to make sure that they can handle that situation, that they are going to be respected as the person who's in charge of your money during a period of incapacity. And maybe it's not automatically your spouse. Maybe it's your sister. Maybe it's your best friend. So we have to talk through this person who's in charge of the money. There's one who's in charge if you hit your head, and it might be the same person or a different person who's in charge of the money after you die. And so this is a really important thing to dig into. Who's in charge of the money if I hit my head? Who does my taxes if I hit my head? Who's in charge of the insurance? And when you have adult children and you have a spouse, it'd be a little sticky, right? So it takes time. It takes time to work through the best possible scenario. The documents themselves, you need them. But all the counsel around the documents, all of the running of the scenarios, equally important. Okay, so we talked about, what about my stuff? So now let's talk about, so we did this one, what about my stuff? You're going to use a revocable trust. Maybe you're going to have multiple revocable trusts depending on the asset profile. You're going to name people who are in charge when you bonk your head. You're going to name people in charge when you've died. You have to spend a lot of time thinking about when people get their inheritance and how people get their inheritance, okay? Now let's talk about what about me? Maybe you're married to someone who has adult children. You don't share a faith with them. You don't share values with them. They resent you. Who's in charge when your spouse bonks their head? You have to put in, so an advanced healthcare directive is the document that gives the person permission and directions. Generally, they say, donate my organs here, cremate my body or bury me, or, press me into a diamond or compost me, whatever. And they say, pull the plug, don't pull the plug. We need to add in more. If you have minor children, I don't want to be used as a cadaver because your kids are little and everybody knows what that looks like. So do that after you have adult kids. If genetic materials are an issue for you, cover that with your attorney. Very important. Please put who to keep out of the room. If you do not want your ex anywhere near the place, write it down so that your current spouse or your adult children don't have to deal with this. It's like you just write it down, give it to the nurse, give it to security, and that person can't come in. Sometimes it's, I don't want them there unless they're comforting our children, can be, one way to do it. Gender identity and presentation, very important to address in an advanced healthcare directive. If you don't share a religious tradition, you have to talk about this. You have to discuss this because What if you're losing your person, your spouse, your partner, and their children are Catholic, but your spouse or partner isn't anymore? How do you honor and comfort the children and get them what they need, and also respect you and your partner's beliefs? And so all of this has to be discussed ahead of time, and all the rules of the game set down in the Advanced Healthcare Directive. Otherwise, explosions. I want you to give it to your doctor, give it to the loved ones, register it with the California Secretary of State, and anybody, talk to the adult children about it. Hey, I know that you expect certain things. We're not going to do those things. And here's why. And I didn't put you in charge, and here's why. Or I did put you in charge, and I expect you to honor my spouse or partner. Make it really, really express and clear how you want this to go. There's also a document called a HIPAA waiver, and that just gives people access to your medical information. You always want your lawyer, you want your doctors, and you want maybe a lawyer because maybe you've been hit by a car and they need your medical records so that they can sue. You want your successor trustee because they're going to be getting all these medical bills, so that you want them to know what it is that they're paying for. So there are certain types of people, but then you want to think about, well, who else should be getting access to my medical records, right? Might be your family, your partner, your adult children. So that's, sensitive, and you want to think about that. For a durable power of attorney, this is the document, that the nefarious nephew puts under the elderly auntie's nose and steals all her money. Okay, that's the classic. It is a big, powerful document. It is a big deal to sign a durable power of attorney. But if you don't, remember at the beginning of the talk, conservatorship. So you have to do this with a lawyer. You can do an advanced healthcare directive. Ask your doctor for an advanced healthcare directive. They will be thrilled to give you one. Generally, like big medical centers have their own version that you can get online. It's really easily accessible, and you can thoughtfully go through and fill one out, add extra pages, take it to your local bank. They'll notarize it for you for free, probably, and then there you have it. The durable power of attorney, I want you to do this with a lawyer. If you try to do this yourself, it's really difficult for a third party to accept it because so many people try to abuse these. This is not usually about the money, because all your money should be in your trust. This is about retirement accounts, which they just can't go in the trust, okay? They can't. So you have to do that under one of these. And then listed here, your employment, taxes, your government benefits, Comcast, the nursing home, all of your contractual relationships. And I want you to do this with a lawyer. So now what about my kids? This can be hard because maybe you are with someone, and if they die, the children wouldn't stay with you, even if they don't have another living parent. So that's something, that's a big conversation, right? And it's really important that you and your partner are very much on board and aware of what is supposed to happen, that you talk through this. I have told you how much I hate wills. Wills are often used to name children. The worst I saw was children's name, birth date, social security number, and the names and addresses of the guardians for minor children. That's a public document. It winds up on the dark web. No, we don't know. Here in California, we can use a separate document. I don't know what happens in your jurisdiction, so you always want to ask the lawyer, can we do this in another document? Is there a way to minimize the impact of this being lodged with the court and made a public document when I die? Who should the guardians be? You want to provide a lot of, we're thinking about your children, and maybe you're not leaving them to your spouse, right? Leave them to your ex-partner. But if they're not alive, to other people. I don't know. Everybody's got a different way, right? Provide the court with a lot of information, religion, education, who they should spend time with, why? Because just because you think Chris and Jordan are perfect and you write their names down doesn't mean that's automatically what's going to happen. The court does its own independent investigation. Who is the best person to take care of these children? and you name Chris and Jordan, but Jordan has 2 DUIs, or Chris has their parents living with them and she has dementia and it's basically a hospice, or they're going to get a divorce, or they've gone to live in Fiji. People are always doing things. And so you want to have backup people, and you also want to explain, these are my people, here are some backups, and this is what we're looking for. This is what we want the court to look into. But it also provides, a mission statement and a kind of a vision board for the surviving parent. We talked a bit about, do the guardians have enough money? What about their children? But what about children in a blended family who would go and live with the other parent? We still want to do this guardianship nomination form. What I have heard over and over again is we get 2 really great results. One is we do this very long form, guardianship nomination form, and we give it to the ex. And the ex says, I love this. If something happens to you, this keeps you alive in our child's life. This helps me as a co-parent with you, even if you're not there. I can't forget what you would have done because you've written it all down. The other is they get really angry and jealous, and then they go make their own estate plan. Yes, that's what we want. We want everyone to have an estate plan so that if you lose your ex, we don't have financial chaos. Because if they don't have an estate plan, a judge might decide, I'm going to put all the ex's money into a locked box until the children are 18. And then you have no money from the co-parent to help raise these children. So it's a nightmare. And so either way, whether they're very gracious and lovely or they're narcissistic and mean, it still will push them to go and get their estate. And that is a win. Tax. Okay. Federal estate tax is not due unless the second to die in a married couple. And that amount is set by statute. Right now, it's like $24 million. Who cares, right? But that number is going to change. It's going to sunset in 2 years, and then we won't know what the new number is going to be. Who decides? Congress. So we'll see the makeup of Congress. In California, we currently do not have an estate tax. The estate tax is paid by the dead person's pile of money. Some states do have an estate tax, and sometimes it's due when the first one dies. Sometimes it's due when the second one dies. So you want to be really careful and make sure that your lawyer understands exactly what the rules are for that state. An inheritance tax, there is none. The beneficiaries of an estate do not pay tax under federal. California, we also don't have that, but in some states, yes. So if you have some kids living in California and some kids living in a state where they might get dinged for inheritance tax, you got to keep that in mind, right? This is something that can become a huge issue because you think everything is fair, but then it's not fair because one kid gets hit with tax. So it's something that you always want to keep an eye on. Make sure you're working with a lawyer who knows what to look for. Here in California, we have really weird laws around real estate. Some of them are pretty recent. Most of them are pretty punitive. So if you own real estate with someone, you have to be very, very careful. Do not, as a blended family, purchase real estate with your partner without a lawyer involved. You have to understand the difference between a joint tenancy and community property. If you take money from your divorce settlement for your prior divorce, and you buy a house with your new person and you take title as community property, and then you guys get divorced, they get half. Terrible. I see it all the time. I see these deeds that someone at the title company said, well, this is how married people do it, so just do it that way. They don't understand that there are implications on divorce and implications on death, implications about how property is divided on divorce, and implications on capital gains exposure on death. So it's really, really important if you're buying real estate in California, bring in a lawyer. It's not required here in California. It should be, because buying real estate here is ultra complicated. Okay, ladies, we are the sandwich generation, right? We are daughters, we are parents. Some of us are step parents. It's that sandwich. You have to ask your parents about their estate plan. You have to ask everybody who's counting on you about their estate plan. Everyone who thinks that you are going to show up in a pinch, they need an estate plan to honor you. It's not about their stuff. It's about them having an advanced healthcare directive and a durable power of attorney. It's also about them having long-term care insurance so that you don't lose your health taking care of them, so that you can be there emotionally, so you can be there in a loving way, but you're not actually the one doing the physical labor of caring for someone. Designated guardians should have an estate plan, right? Don't leave your kids to somebody who's disorganized. Did your mom put you on title to the house? This is really typical. We don't want this. Not a good tax result. Also, mom doesn't have to tell you if she did this. And maybe she did this, but you don't have good insurance. So you go out and you cause a big car accident and nothing's showing up in your name except for this house that you own with your mom. It's not a great result for mom. So very careful about that. Whichever lawyer you work with, ask them to pull the deeds for all of your family members to see who has their title and trust and make sure that mom did not add you. If you move out of state, you need to have local counsel look at your estate plan. I've said California's community property, California's weird about real estate. California doesn't have inheritance tax. I don't know what goes on in other states. So if you cross into another jurisdiction, you have to have a lawyer in that new jurisdiction. Take a look at your documents. And then if you move out of the country, you need a new estate plan. Okay. Different countries do it differently. If you're going through, if you're using assisted reproductive technologies, if you're using IVF, if you're adopting, you got to talk to your lawyer about it. There are different laws in different states about IVF, about our embryo's property, about inheritance. So that's really something to drill down on. If you are a green card holder, you have to look into whether or not you need some additional drafting to get around some IRS oversight. If you're here on a visa, you have to work with a lawyer who knows how to do that, who knows how to read the treaties between the two countries and can help you with all the life insurance work that you're going to have to do to beat the taxes. If you have foreign income, just as a note, make sure your CPA knows what they're doing, because if you screw up your foreign income, you're not going to be happy. My unmarried couples. Okay. No common law marriage in California. Most states have eliminated common law marriage. It doesn't matter how long you are together. You never, so no benefits of the family law code or the probate code. So if you break up, you don't have a rule book. And when you die, there is no rule book. You cannot do nothing. Okay. You either have to get a cohabitation agreement for who gets what if we break up. And this whole talk has been about you need an estate plan, right? You can get married. Don't get married until you understand what the family law says in your state. Sit down with a lawyer and get an education. If I get married, what does it mean regarding the stuff I own now? Any money I might make while I'm married? What about the other person's debt load? What does it mean if we get married, right? And then can I opt out of any of that? Ooh, it's like, oh, I like these first 7 things you talked about, but those last 2, I don't love that. Can I opt out of those? Am I allowed to opt out? And the way that you opt out of the family law code is with a prenup. You cannot do nothing. You cannot do nothing. You cannot do nothing, okay? If you're living in your partner's house and they die, what do you get? Nothing without a fight. It's dangerous, and it's really important, the cohabitation agreements in case you break up and the estate plan in case someone dies. You may not use online forms. I used to be really worried about these non-lawyers, about all these companies that, oh, we're leveraging technology to make estate planning equitable for everybody. Those forms are garbage. They're terrible. I see them all the time. They are trash. What I am now newly very concerned about is lawyers using technology to have clients basically do their own data entry into software, because good lawyers do use software. I use software. And then they just print out forms or they just create these forms and email them to the client and say, here are your documents after a 30-minute phone call. No, we're not going to do this. I don't care how cheap it is. You have to protect yourself. You have to protect your kids. You have to protect your union. You have to protect your family. And it's inappropriate to look for the cheapest way to get this done. You are just not going to do that because it's not going to ultimately work. Some insurance considerations. I like insurance. I want to see life insurance. Can't spell. Used as a tool. How do we make sure that the surviving spouse or partner has enough money to whatever, pay off the house, get the kids through college, whatever those things are, right? Replace income. Is there enough money? If we have children who are in their 20s and then more children who are elementary school age, can we use life insurance to provide a gift for those older children so that they're not waiting for the younger siblings to grow up? They're not waiting for a step parent to die before they get their inheritance. I think life insurance can be a terrific tool. I do not sell life insurance. I encourage my clients to work with a financial advisor to figure that out because you don't want to be insurance poor. And you do not buy your life insurance online either. It is complicated. Doesn't cost any more to work with a professional who knows what they're doing. I want you to talk to your partner about disability insurance. The number one thing anybody owns is their ability to make money. So that needs to be protected because that protects the family. Because what you don't want is to be in a situation where the breadwinner can no longer work. And so what are the priorities? Are we no longer paying for college so that we can support the breadwinner and their spouse? How are we doing this? That's an explosion. And so insurance can really be used as a Band-Aid to cover a lot of scenarios. And long-term care insurance is really important. We need to protect our kids from us getting old and disabled and rickety and falling apart. It's something also to consider between partners. It's going to be stressful if you or your partner in a blended family are going through this. If you're going through an extended period of illness, I would rather that the time and energy be spent in loving collaboration than in screaming at each other over who's going to pay for what and who's supposed to be cooking today and who's coming over to help bathe the patient, right? It's a lot of stress with people that are already in a step relationship, which can already be a little bit fraught. How to find a lawyer. Okay. Education. So sometimes they have a master's degree. Sometimes they've just been doing it for a long time. They might be a certified specialist. I have a master's. How long have they been doing this? And how long have they been doing this with blended families? They know how to spot the issues. Other areas of practice, if they're doing family law and bankruptcy law and entity formation, I don't like it. They should be estate planning lawyers. That should be what they do. That's the core of who they are and what they have devoted their practice to. You have to be able to talk to them. The emotional side is really important, and I want them to use software. Estate planning is a huge area of the law, and it's impacted by tons of other areas of the law. So if you aren't using the software, really good software, you might miss a trick in your documents where everybody using software knows we don't do it that way anymore. But if you're just buried using your own documents, you might miss it. In California, the cost is usually between $4,000 and $6,000. It might be a little bit more for a blended family. And then if we're doing your marital trust and then separate trust, these numbers can go up, but it's way cheaper than the alternative, right? I want you to spend at least 4 hours with the lawyer. The lawyer should learn a lot from you. You know, this is not 30 minutes. No one can get to know you in 30 minutes, okay? We're not doing that. The client's learning meeting, a full document review, and then a meeting on how to transfer your stuff to your trust. Our malpractice insurance is expensive. The software is expensive. You are not looking for a cheap lawyer. You are looking for a good lawyer. It might be that you have some really great work benefits. Take a look at your employee benefits package. There might be a free lawyer in there. They get paid really little. You want to set all of the expectations ahead of time because they will upcharge you for everything. They're usually also junior lawyers. The timing we talked about a little bit before. This is months, not weeks. I want you to make sure that you have umbrella insurance. If you don't know what that is, just write it down on a Post-it, put it right on the front of your computer, right over my face, umbrella insurance, and make sure you have it, and that every adult living in your house has it. It's the #1 way to protect your assets. Make sure that your lawyer has a good network. They should be helping you find someone to do your umbrella insurance, your life, your disability, your long-term care. A good lawyer has a really big professional network. Interdisciplinary learning is really important for estate planning lawyers. We can't be good issue spotters if we don't know what our colleagues in related industries are doing and what they see as important. I will throw these things into the chat in case you are in California. Yep, all 3 things are in. I have a question. If the stepmom is the beneficiary of the life insurance policies, are the proceeds characterized as separate or community property? It depends. And I'm not a family law attorney. Okay, I'm not a family law attorney. So it depends on which state you live in, and it depends on what money was used to procure that life insurance policy. So I don't know. I don't know. It depends. And just, I can't give legal advice. So I'm going to stop this screen share. And if you have questions, you can, you don't have to show your face, but you can go ahead and unmute and ask a question or raise your hand, or you can drop it into the chat. I know we covered a lot, and don't be afraid if you think, oh, she already said it, because you can get emotionally hooked on one thing I said and then miss the next 2 minutes. I'm happy to repeat. Or was I that good?
Could you go back over about pulling deeds on all family members?
Yeah, why do I do that?
Yeah.
Sure. So what I'm looking for is I want to make sure that every family has an estate plan. It does not serve my clients if the only thing that I do is their estate plan. I'm all about promoting family harmony and making sure that women, this is a real mission for me, women are protected. And so I want all of my clients' parents to see their estate planning lawyer. I don't work with them. I want them to have their own independent lawyer that they see consistently every 3 years. I want everything buttoned up perfectly. And if I pull a deed and I see that the house is not in a trust, that's an immediate red flag that something hasn't happened. And sometimes it's a simple thing. We did a refi and the title company, they took it out of the trust for the refi and they didn't pop it back in. Sometimes it's that simple. Other times the parents have a trust, but they never transferred the property into the trust for whatever reason, they forgot. And sometimes it's, oh, we only have wills and we haven't thought about this for 20, 30 years. And so it really is time, because what estate planning will do is we're going to marshal all the assets. You have to list them all. We're going to talk about who all your advisors are. You're not going to use this garbage online insurance anymore. We're going to make sure that mom and dad have a financial advisor, because if dad passes and mom doesn't know how things are invested, it's a huge stress and trauma for her. We want to make sure that everything is set up perfectly, in case one of them becomes incapacitated or one of them dies. Because by doing that, I am protecting my clients from unnecessary chaos. I'm a big mother, and Susan has a question.
Yeah, thank you, Patricia. You know, I've heard you talk about leaving a little bit to the children upon the death of their bio parent. And I wonder if you could address this again, because it's more customary, I believe, that when one spouse dies, the estate is turned over to the surviving spouse. But you have suggested that maybe providing a little money for the children before the surviving spouse.
Sure, or a lot of money, right? Because maybe you've married someone who has a bunch of minor children, and so they die and they're not contributing anymore. They're not contributing for school, clothes, soccer, all the things. And maybe they really dislike their ex, but they don't really dislike their children. And so we have to provide all of that financial support. And so it really is a matter of what is appropriate. It gets trickier when you then have a child with that person, right? So we've got multiple tiers of minor children. How are we dealing with all of this? It's So I love life insurance because they're nice, clean numbers. But sometimes it's you've married someone who has a bunch of adult children. You do not want them staring daggers at you, waiting for you to die. You don't. It's not nice. It's not a nice way to live when there are a whole bunch of people out there just, just waiting for you to kick the bucket so that they can have their inheritance, but also very suspicious of you because the way that a lot of estate plans are drafted is everything to the surviving spouse, who can then change everything about this trust and leave their money to whoever the hell they want. And so it creates a really toxic stew. And there are other ways to draft. There are other mechanisms that you can use that say money to the surviving spouse to use in a certain way, and any money that is left over goes to my kids. So there are other mechanisms that you can use to honor all of the relationships, to take care of everyone. And maybe when the step parent dies, there is no money left over, but it was used up because the step parent had long-term health issues, because the economy tanked, because things happened, and not just because they decided to go marry someone else and live on a cruise ship. Because these things happen.
The question I had was around the retirement. I think I missed that. I think you maybe were alluding to the fact that it doesn't get included in the trust. Is that what
It's
you
just
were
not,
saying?
sure, it's not a trust asset because it cannot be. You cannot take title. You can take title to a bank account. You can say, oh, this used to be Tiffany's bank account. Now it's Tiffany, trustee of the Tiffany Trust bank account. You can transfer your home into your trust. So you own it as Tiffany, trustee of the Tiffany Trust, right?
Mhm.
You can't do that with a retirement account. And so a retirement account, if you're incapacitated, is controlled under a durable power of attorney, not by the trustee. The other thing is that retirement accounts are tricky. And it used to be that you could leave your retirement account to a baby, and all that money would grow interest-free until the baby grew up to take the required minimum distribution. Baby takes out just the amount they have to, and then they leave it to a baby. And then it grows again interest-free for decades. Congress got rid of that. So now between spouses and between people who are within 10 years of each other, they can just let it grow until it's required minimum distribution age. It's different now for children. They have to take it all out within 10 years. And so, but that can be where a huge amount of money is. And so sometimes you've got, sometimes it really becomes an issue because we don't want the tax exposure, but it doesn't make sense to leave it all to the surviving spouse. And so it's just a sticky problem that can take a lot of counsel and decision-making, and you just have to approach it calmly. And if you go to your financial advisor and say, hey, I went to this thing and this woman was talking about the Secure Act, and they say, oh, the Secure Act, it's okay. We're still waiting for all of the regulations from the IRS. We haven't seen it tested in the courts yet. We haven't seen any letter rulings from the IRS yet. And so it's a little bit of a muddy, sticky area. And that's also why I want you to see your estate planning lawyer every 3 years to make sure the retirement accounts are addressed as correctly as they can be under this always changing area of the law. T, I think, had a question. She unmuted.
Yeah. So do you need a cohabitation agreement if you both have trusts in place already?
Yes. What if you break up? The
So
cohabitation agreement addresses what happens if you break up. The estate plans address what happens when you die. Two very different scenarios.
So if I owned everything before the relationship and he came in with nothing, would it not be assumed that we leave with that? We need to have something in place similar to being married, like a prenup?
Here in California, we are seeing a lot of problems around this. He moves into her house. He's taking care of everything. She's off building her company. They break up. And he says, you couldn't have done all that without me. I own a piece of that company. And by the way, I took care of this house and I would like a piece of this house. And these things are being mediated. We have not so much seeing them in the courts yet, but these things do happen. You need to protect yourself. I would not let my unmarried partner come live in my house without a cohabitation agreement.
Thank you.
I am paranoid. See a family law attorney. I think, and it's when I work with a couple who is just fresh off a prenup, or I'm work with a couple who's fresh off of a cohabitation agreement, it can be a little bit of a sigh of relief when it gets to the estate planning. It's like, okay, well, before you were doing this scenario where you can't stand the sight of each other anymore, you can break up. I'm working with you on a scenario where you die and it's still a loving relationship. So now where does the stuff go? Now, how do we look at this? So it's a little bit of a different track. And, it's a huge issue here in California. In other states, I don't really know how it works, but it's definitely something to talk to your estate planning lawyer about and see if they have a recommendation to a really good family law attorney, because your estate planning lawyer should not draft your cohabitation agreement.
Thanks again.
Such a good question. Thank you, Susan, for having me here. I'm glad that we recorded this, and I hope that it's useful for people down the line. I want to say that it is September 2022, and the laws are always changing. And so what we talked about today is for today-ish. So you always want to check in and double check and triple check every few years that your documents are up to date and that you're doing everything you can to take care of yourself, the people you love, and that you are being respected and taken care of by the people who are counting.
Thank you, Patricia. This was brilliant. I really appreciate it. And thanks everybody for showing up and being here.